Thank you, Chair. Thank you all for being here. Good to see you again, Mr Furlong. When the Fair Work Commission assesses the application of the Better Off Overall Test, the BOOT, to a proposed enterprise agreement, would it be a normal expectation that the pay rate under the enterprise agreement should be clearly equal to or above that of the relevant award?
In terms of the... Murray Furlong, General Manager of the Fair Work Commission. Senator, as you're aware and as we've discussed in previous estimates, the agreement-making process involves a statutory decision holder, a member of the Commission, looking at the facts of the matter and then applying a legal test, the Better Off Overall Test, and there's some other elements of, that they're required to sort of satisfy, and on the basis of that, they make a determination about whether or not the agreement is to be approved or not.
Would it be a normal expectation that the pay rate under the enterprise agreement should be clearly equal to or above? A normal expectation?
Yes. I mean, the Better Off Overall Test.
Are there circumstances in which, when considering the Better Off Overall Test, the BOOT, for an enterprise agreement, the Fair Work Commission would not do a comparison against the relevant award?
The answer to that question is that there will be an award that they will refer to in terms of the application of the Better Off Overall Test, and through that process they will determine whether or not that agreement, as made, is better off overall than the underpinning agreement.
So they would do a comparison against the award?
Yes.
Thank you. If the enterprise agreement pay rate were not equal to or was above the relevant award, and instead paid substantially less than the award, what would be the criteria used to justify that the enterprise agreement still passed the Better Off Overall Test, the BOOT?
It's not a line-by-line comparison.
No, but what would be the criteria?
Well, it would be...
Broad criteria, line by line, whatever you want.
It's the Better Off Overall Test, and the Fair Work Act prescribes what the member must take into consideration in determining whether or not that agreement meets the requirements to be approved.
Are pay rates prescribed in there?
They will be.
Okay.
The decisions of the members, the independent tribunal members, will outline the reasons for the approval of those agreements, including whether or not they satisfy the Better Off Overall Test.
Oh, that's a wonderful point. Thank you so much. If an award excluded certain classes of employees from its provisions, would that exclusion create the legal circumstances to pay such excluded classes of employee less under an enterprise agreement than what they would or could earn under the award if the class of employees were not award excluded? So, just to be clear, I'm not posing a theoretical question here. I refer to the Black Coal Mining Industry Award exclusion of casuals as an example. That it's not, casuals are not specifically referred to in the Black Coal Mining Industry Award.
I understand that, but as we've discussed in previous estimates, the fact that there is no casual coal miners under the Black Coal Mining Award doesn't preclude an enterprise agreement being made.
Oh no, I understand that. I'm talking about the pay. If an award excluded certain classes of employees in the coal industry, casuals, from its provisions, would that exclusion create the legal circumstances to pay such excluded classes of employee less under an enterprise agreement than what they would or could earn under the award if the class of employees were included in the award?
Senator, I've tried as hard as I can to be helpful in terms of the circumstances.
Oh, you're being helpful.
You've provided. My role as the General Manager is to provide administrative support to the President in the efficient running of the tribunal, in essence. The matters that you're going to now traverse instances or occurrences that may end up before tribunal members for their determination. So I can't answer that question.
That's fine. Thank you. Minister, what would be the attitude of the government where workers working under enterprise agreements were paid less than the award even though the workers were doing exactly the same job they would under the award?
Well, I would want to know more about the circumstances there, but in general, the idea behind enterprise bargaining is for people to obtain pay and conditions above the award level.
Okay. Why is Minister Burke shirking his responsibilities and refusing to provide justice for thousands of workers caught in the permanent casual rort that is the result of enterprise agreements agreed between the CFMEU, now known as the Mining and Energy Union, with some labour hire firms, all with the Fair Work Commission's approval. When will Minister Burke address this, the largest wage theft in Australian history?
Well, as we've discussed many times, Senator Roberts, Minister Burke is not avoiding that. In fact, Minister Burke has led the government's efforts to address the permanent casual and fix the permanent casual rort, including through the legislation that we passed only last week. I actually don't remember how you voted in that legislation, but
I voted against it because it would not address the issue that I'm talking about right here. It buries the issue and buries the culpability.
I thought you probably voted against that legislation last week because One Nation has pretty consistently voted against.
We voted against it, as I explained, Minister, because it doesn't address the issue, it buries the issue.
Just like you voted against the Closing Loopholes bill last year that was all about trying to put labour hire workers on an even footing with other workers.
Not true, Minister.
But, well, One Nation has consistently
You're
voted
consistently avoiding the issue of thousands of casual coal miners in the Hunter Valley and Central Queensland, our own state.
Well, I
want that addressed.
We're not, and we've gone over this ad nauseum.
Okay, to make a point here concerning the validity of an enterprise agreement that removes the minimum statutory protections of any award, I quote the following paragraph from the full bench federal court decision in One Key Workforce Proprietary Limited versus Construction, Forestry, Mining and Energy Union, decided in 2018. I go to paragraph 227. This is from the court decision. It is uncontentious that where a statute requires an administrative decision-maker to reach a state of satisfaction about a matter, the opinion as to the state of satisfaction must be reached by a rational, reasonable and logical process. And I go to paragraph 204. Quote, it is an error of law to fail to have regard to relevant material in a way that affects the exercise of power. An administrative decision-maker who makes such an error exceeds his or her authority and acts without jurisdiction. End of quote. I'm going to read.
So, if we keep to the timeline, I'm just giving you a heads up.
I'm nearly done.
Yep.
I've got 2 questions and I'm going to read some material. We had a team of workplace lawyers, and I emphasise plural, consultants and coal miners, review and analyse 5 significant labour hire coal mining enterprise agreements and their work roster, which is complicated. The CFMEU, or now the Mining and Energy Union, were involved in, were a party to or signed off on all 5 agreements. The Fair Work Commission approved all 5 agreements. The enterprise agreements all underpaid the award dramatically. Specifically, the Core Staff Enterprise Agreement 2018, the yearly underpayment for casuals working under that award is estimated at $22,623. Wage theft. The FES Agreement 2018, yearly underpayment estimated at $27,563 of wage theft for casual workers. The WorkPack Agreement 2019, yearly underpayment for casuals estimated at $33,555, wage theft. The Chandler-McLeod Agreement 2020, yearly underpayment estimated at $39,341, wage theft. The Tessa Group Agreement 2022, yearly underpayment estimated at $40,645, wage theft. The Fair Work Commissioners who ruled on at least 5 black coal mining industry enterprise agreements exceeded their authorities. What avenues will you, Minister, what avenues will Minister Burke and your government take to restore basic entitlements lost under agreements that the CFMEU, Mining and Energy Union, signed with various employers and that the Fair Work Commission approved?
Well, Senator Roberts, I've personally sat through probably at least half a dozen Estimates Committee hearings where you've raised these issues repeatedly. Various officials have answered these questions repeatedly, and the matters have been investigated, as I understand it, and dealt with. I understand that you're not satisfied with those answers, but I can't add to what we've said about these things before.
Does it bother you that I've explained that the Fair Work Ombudsman has used a fraudulent document that's been deemed fraudulent by the Australian Taxation Office as evidence against 5 other solid evidence, including court hearing?
Well, if that were true, of course, I'd be bothered by it, but I'm not sure that that is true.
Okay. Last question, Chair. Why is the process that the Fair Work Commission has adopted since 2010 in approving coal industry enterprise agreements that remove the minimum statutory protections of the Black Coal Mining Industry Award clearly devoid of any form of rationality, reasonability or logic?
Sorry, I don't. What was the beginning of that question?
Why is the process that the Fair Work Commission has adopted since 2010 in approving coal industry enterprise agreements that remove the minimum statutory protections of the Black Coal Mining Industry Award, its entitlements, pay rates, the wage theft that I've just illustrated, why is it clearly devoid of any form of rationality, reasonability or logic, as the Federal Court requires?
That's obviously your opinion, Senator Roberts, and I know it's a strongly held opinion, but I don't think that opinion is shared more broadly.
Thank you, Chair.
Good, thanks very much.